This hearing is on Senate Bill 324, eliminating the Land Use Board and requiring approval of federal land acquisitions by the Governor and Executive Council. And I'm going to recognize Senator Avard as the prime sponsor, but I'm going to brief the rest of you to start crossing out the lengthy parts of your testimony, because we have more than 7 people who want to testify. This is scheduled for roughly half an hour hearing, so 2-3 minutes each, please. Senator Avard?
I can introduce it for him if you'd like.
Thank you, yes.
Okay, just send it up, please.
One seat, then we have to go back for a hearing.
Thank you, Mr. Chairman. I'm Representative James W. McConnell, a co-sponsor of this bill. This bill eliminates the Land Use Board and requires approval of federal land acquisitions by the Governor and Executive Council. It essentially requires the state to adhere to the requirements of RSA 121, and that law has been in existence for 80 years. And thus far, as many of us can tell, hasn't been recognized at all, and obviously it has to be. The law essentially requires that the federal government adhere to the limitations that we've put on their acquisition of property in the state. 2% of the land area of the state outside the White Mountains, and 5% of any town's assessed base.
Thank you. Don't see any questions for Mr. Representative McConnell, so thank you for your testimony. And I haven't sorted through these properly. Are there any other senators or representatives who turned in a card? Yes.
I noticed that we have an amendment before us.
We don't have an amendment yet.
Okay, I'm wondering if the people who are here to testify might want to be able to weigh in on what we may be considering, because otherwise we will not have their input on it when we are executing on it.
I'm happy to introduce the
Fair
amendment
point.
as
You
well.
want to give us a quick on the amendment, Mr. McConnell?
The amendment indicates that whereas with respect to the 2% limitation on federal land acquisitions that exists in the 1935 law, that the White Mountain area properties that are within that boundary would be included in the 2% on subsequent acquisitions. As it stands right now, the existing law says that anything within the White Mountain National Forest boundaries shall not be included in the 2% calculation.
Okay.
It's not what it says.
Lays the
That's not what it
ground.
says. What's it say?
Basically, it's, may I speak?
Tell me.
Basically, it
Can you
says,
state your name, please?
Ann Cartwright, Outstead, New Hampshire.
Okay, we've got you down for later testimony.
Yes.
Okay, thank you. Thank you.
You betcha.
Brad Simpkins.
Good morning, Mr. Chairman and members of the committee. For the record, my name is Brad Simpkins. I serve as the Director of Division of Forests and Lands within the Department of Resources and Economic Development. I appreciate the opportunity to testify today regarding Senate Bill 324. I do have written testimony. I will try to be very brief. Senate Bill 324 it makes several changes to the current statute RSA 121 regarding proposed federal acquisitions, but I just wanted to mention 3 different areas that I want to make the committee aware of. First thing I want to mention is the bill as currently written prior to the amendment, DRED does not support. The way it came out of the Senate, and it was inadvertent, but the way the language says, it basically would prohibit all federal land purchases if the bill was passed. So I believe the amendment is meant to fix that. With that fixed, DRED would take no position on the bill and would remain neutral, so I just wanted to put that out there. There are three things that I wanted to mention. One of the first things this bill does early on is there was a section in existing law that talks about net income from federal lands and where that goes. That is an outdated law, and there have been several more recent laws, and it's in my written testimony, but specifically 227G5 and 227H24 that pertain to income off of federal properties. So that was struck because there's other more recent laws that deal with that. The second thing that this bill does is it takes out the exemption for lands owned by the White Mountain National Forest. Under the current law, lands purchased by the White Mountain National Forest are exempt from the 2% statewide limit and the 5% valuation per town. The way that section is removed in the current bill. Because that section is removed, what that does is it bumps up the total ownership well over the 2% limit, because the White Mountains is already about 13%, and that's the inadvertent portion in this current language that would basically shut down all federal land purchases. So again, I believe the amendment, which someone will speak to more later on, would try to fix that. The last thing I wanted to mention that this bill would do is a brand new process. It would require a certificate of compliance from our agency. So basically what it would do is a registrar of deeds would not be able to legally record a deed unless they got a certificate from our agency saying the federal entity complied with all aspects of RSA 121. That's a brand new process. I don't know how that would work, but I want to at least point your attention to that. So just in closing, we've been working with the House and Senate since the beginning of the session on several of these bills regarding federal land acquisition. I believe the primary concerns have been a lack of communication and public input before acquisitions. And DRED, even though we're not taking an official position on the bill, we just want to make sure that if there's special places that need conserved and need protection, that we're able to do that. And we want to make sure we have all the tools left in the toolbox to be able to do that. And there are certain circumstances where maybe it makes sense that the federal government should own a particular piece of property. So that's kind of our thoughts on the issue. I'd be happy to try to answer any questions, but I'm trying to be as brief as possible.
Representative McConnell, as a sponsor, you're not supposed to take part in the hearing.
Oh, sorry.
It's okay.
Okay.
Representative Smith.
Thank you, Brad. Do you, overall, do you think that this bill is accomplishing anything?
So I think it does a few things. One is the original statute, as we know, was written back in the 1930s, and it's quite outdated. So some of the things that this amendment does is just update, like it takes out land use board, replaces it with DRED, which it already happened back in 1961, but kind of you have to follow the different statutes to figure that out. So it kind of cleans up the law. It does spell out a pretty clear public process as far, and again, that's a policy issue, but it would require town votes, it would require governor and council and those types of things. So it does kind of clear that up on how that process would happen. Again, for us, our big thing is we didn't want to shut the door on any possibility, and if there's an area that we all agree is really special and needs to be conserved, and the federal government may be the only one that can do it because of funding or whatever, and it's the appropriate thing to do, we wanted to make sure that tool is still available in the toolbox. But as far as local input into the process, we think that's very important too, and I think that's been part of the issue is I think there's been a lack of communication and maybe that local input prior to some of these acquisitions taking place. And we certainly do support, the public knowing what land is being purchased and why and those types of things.
Hope to follow up?
Follow-up?
Yes, thank you, that's making things much clearer. When you say you want to retain that tool to be able to go in on a particularly valuable piece of property, right now, what, or under this bill, what would prevent you from being able to do that? Is it the 5%, is it the 2%, is it?
The bill is currently written without the amendment. Takes away the exemption of the acreage on the White Mountain National Forest. And there's another section of the law that says there's a statewide cap of 2% on lands that can be owned by the federal government for conservation. So if you remove the exemption for the lands already owned by the White Mountain National Forest, you pop up to like 13%. So therefore, that would have the effect of shutting down any federal land purchase. So that's the part we have the big issue with. If that was removed, so basically the lands that had been previously exempted stay exempted, then those would not be used in that 2% calculation going forward. So that's our concern.
Yeah, to follow up, I understand that part for the statewide numbers.
Yeah.
Are you concerned that town by town, we may not be able to acquire land because of the 5% cap on each municipality?
So this amendment, that's another good point. One of the changes in this amendment is the assessed value, the 5% assessed value. The current law, RSA 121, just says it can't be more than 5% of the assessed value on April 1st of the preceding tax year from when the acquisition took place. This would change that to the highest and best use, which would be different. So if under existing law, a federal agency was buying a piece of land, and if that piece of land is in current use today, for example, that's what we would be comparing that against. But what this would do is look at what is the highest and best use of that piece of property, regardless of what use it's in right now. And so that may get it to the 5% much quicker, but there is also a mechanism that that 5% could be exceeded with a town vote.
Good, thank you.
Representative Francis, did I see you?
Yes, I did have my hand up. Thank you, Mr. Chairman, and thank you for taking my question. I just want to be clear, when I was reading this, without the amendment, I was concerned that what might happen here is that local community, towns, cities, the voice of the voters at that level would be somehow, what do I want to say, sort of minimized in what we're proposing here in this bill. Will it be as strong or as influential if we were to adopt this bill? Will local voters have the same influence?
Yeah, I believe they certainly would, probably actually more, because this lays out, I believe, DRED would be responsible for holding a public hearing before a vote if the town requested it and those types of things. So yeah, I believe it would still.
Okay, I read it incorrectly then. Thank you.
Further questions?
Representative
Yes,
Oxman.
sorry, Representative Oxman.
Just to follow up on the highest and best use. I see all kinds of problems with that, because someone could theoretically say, oh, but the best use of this land would be to have a nuclear reactor, and that would bring in, 6 gazillion.
You have a question?
The highest best use, do you also see, you brought up the current use as extrapolating against that, but do you also see other possible problems with that highest and best use?
Well, so that's new. That is something that the Senate wanted to see. Their thought was looking at what the town may possibly be giving up in future tax revenues. So they wanted to have the highest and best use to show what it could potentially be the losses in the future. So, the language in there, I believe, came from DRA as far as a certified assessor under RSA 21J 14-F, because that's, if you're looking at what the current assessment is, that's pretty simple. You just look at the tax card, and I can tell you that. If you're looking at highest and best use, that is a process. You're going to need a certified assessor or appraiser, and that's a much bigger process. So how that would work, I'm not sure, but that was the feeling, is that they wanted to see what's the future potential value of that piece of land.
Highly probable.
Thank you. See no other questions for Mr. Simpkins. Thank you for your testimony.
Thank you.
Ann Edwards, Attorney General's Office.
Thank you, Mr. Chair. Good afternoon, members of the committee. I'm Ann Edwards from the Attorney General's office. And I'm here to speak on information on sort of a general issue. We have records that go back a long time in the Attorney General's office, but we couldn't find anything on legislative testimony from 1935. So I'd like to hope my predecessor came in 1935 and raised the same concerns that we're going to raise, specifically with respect to Section 6, but it also applies to the existing law, which is cited to under Section 5, is this law restricts private landowners' rights to sell their property. And as we all know, when the state is restricting a private landowner's right, that can sometimes be considered to be a taking of the landowner's right. So we have concerns that the certificate of compliance in Section 6 and also the existing language in Section 5 regarding private landowners has the potential to be considered a taking of private land rights. And if that's the case, then it's likely not enforceable. That's my only comment.
I'll ask the obvious question, I guess. Have there been any tests of that in the last 80 years that we're aware of?
With respect to this statute, not that we're aware of. But also Section 6 is a new section, so now you're going to have registries that are going to refuse deeds. So it's, I understand the reason for the check and balance added there, but now that's going to bring heightened attention to this.
Representative Wright.
Thank you. Thank you for taking my question. Is there anything in this that would prevent the federal government from taking property by eminent domain?
There's nothing specifically in here, but in the existing law, there is a provision in RSA 121, which I believe is :8, which does prevent the United States from acquiring property by eminent domain unless it is so agreed to by the landowner. Again, I'm not sure that's an enforceable provision, and I assume my predecessor in 1935 might have testified to that as well, but that is our current state of our law.
Any additional questions from Ms. Edwards?
Thank you very much.
Nice job.
Matt Leahy?
Thank you, Mr. Chairman. For the record, I'm Matt Leahy. We first do want to thank you and the members of this committee for rejecting HB 1291, which is a bill similar intent to this bill. Unfortunately, SB 324 is just as troubling as HB 1291 was. And as we pointed out during consideration of that bill, the decision to sell property or property interest is one of the most personal and financially significant decisions a private landowner will make. And most land trusts who work with these families can attest to the years of careful planning that occur after the initial conversation with a landowner before conservation easement or fee title sale is finally executed. SB 324 does not offer support to landowners who are considering such a major decision. Instead, it creates barriers to the exercise of private property rights by landowners who have made the decision that conserving their land is in the long-term best interest of not only that property, but of their family and community. And the arguments of those who support the bill appear to be responding to concerns about federal land ownership in both the Conti and Alvega National Wildlife Refuges. And specifically, SB 324 supporters assert that the federal government is acquiring properties in both refuges through forced takings. This is untrue. And as stated on the agency's website, U.S. Fish and Wildlife Service only acquires interest in land from willing sellers. So if the agency is not forcibly taking properties, why is this legislation needed? And why should the state of New Hampshire intervene in a transaction between a willing seller and a willing buyer, regardless of who the potential buyer is? So thank you again for this opportunity to present our concerns about the bill, and again, we urge you to vote SB 324 and expedient legislation. I'd be happy to speak with you.
Thank you. Having not been distributed 2 weeks ago or something, have you, or the organizations you represent, had an opportunity to form a position on the amended?
No, we have not seen the amendment. Just based on the description, honestly, I think our concerns are the same. There still is, you know, and again, I've not seen the actual language, but my sense is it still creates that barrier to a private landowner who's trying to, who wants to sell a conservation interest in their property.
Any questions for Mr. Layton? Seeing none, thank you for your testimony.
Thank you.
Representative Itzy?
Thank you, Mr. Chairman. Thank the members of the committee for taking the time. For the record, I'm Representative Dan Itza. I represent Rockingham County District 10. I would like to discuss the private property rights because that issue was raised in the previous hearing, and it is a valid concern. However, one of the things that we have to look back on is our own Constitution, which admonishes us in Article 3 that our natural rights are not absolute. That when we enter into a state of society, we give up certain of our natural rights for the protection of other rights. And there are only certain classes of rights that are unalienable, that is, rights of conscience, religion, things of private nature. We're talking about property rights, and our property rights are not absolute. The state has the power to compel taxation. The state has the power to compel fines when one commits a crime. So our property rights are not absolute. Another issue that happens in this particular case is that by selling this land to the federal government, it can put a town into the situation of being unsustainable. It can no longer generate the taxes, or the tax burden becomes so high on the remaining land that nobody can afford to stay there. The property rights of the individual, their right to sell their property to the highest bidder, has to be balanced against the common right to maintaining the town's sustainability, and in the extreme, the sustainability of the state. The state's created to protect our property rights. If we so debilitate it that it can no longer do so, then we have a problem. Then those property rights are no longer protected. It's the wisdom of this committee to determine what that threshold is maybe. Is it 2%? Is it 1%? Is it 3%? How much of the property in a town can be afforded to be taken off the tax rolls before the town can no longer support its services? Those are serious questions. But the right of property ownership and the right to sell that property to, for instance, the federal government cannot be absolute. And remember that we created the federal government. It's not just some ethereal thing out there. The states created the federal government for the protection of the states. And if that federal government should purchase so much land that it jeopardizes the security of those very states that it was created to protect, it's no longer fulfilling its constitutional obligation. I leave it up to you to figure out what the right thresholds are. Certainly, actually going through and figuring out how much land is no longer under the control of the state or the citizens of the state is a very valid and necessary activity. I'd be happy to answer any questions.
Thank you, Representative. Questions, Representative Itzy? Yes. Representative Gould.
Is it sort of a, thank you very much. Is it sort of a question of states' rights versus the federal?
It's actually, you got three parties. You got the individual, you have the state's sovereignty, and you have the joint sovereignty of the federal government.
Follow up?
Is it theoretically possible that everyone in the town would be willing to sell it to the federal government and it would be 100% owned by the federal government? Is that a possibility?
I guess that's theoretically possible. I mean, one of the things that, another thing that you have to really consider is that there are very few legitimate purposes that the federal government has for purchasing land. And it's generally for putting buildings on. There's no authorization under the Constitution to buy land to create a park. The enumerations are specific. It's forts, magazines, docks, and other needful buildings, so you might consider a federal building. Elsewhere in the Constitution, there's a power to create post roads and post offices, which the post offices are buildings, so you could have a federal land purchase to put in a post office. I don't see any of those things going in the Silva Contes. I think it's highly unlikely that they're going to put a federal building there or a federal courthouse. So I question whether there's a legitimate federal purpose there in the first place, without amendment. And finally, I think we'd be well advised that one of the things we have in state law, and it's been there for a long time, about the same period as this law, is that if the federal government purchases land to put in a building, and that land is going to be tax exempt from the state or the locality, that the federal government has to put in building, a survey and building plans of what's going to go there. Would anybody care to know how many such plans have ever been submitted to the state Secretary of State? Zip. That means that literally the tax exemptions that we've been granting the federal government for the last umpteen years have never been completed, and they actually owe us the tax.
Go after every post office.
Representative Oxnard?
Yes, thank you for that question, thank you, Representative. Are you also concerned about land in the hands of nonprofits or churches, which also diminish the tax base of our towns?
In as much as churches, well, I don't see them individually or collaboratively ever mustering enough capital to constitute a real existential threat. I mean, they're never going to.
And you do feel that national parks are an existential threat?
I believe that the federal government has the power to muster enough cash to create an existential threat, yes.
Just a minor detail. Can I ask you to rotate these two signs so the public can see who they are?
I thought that you could remember who they were.
Yes.
Yes, cheat sheet.
Representative Spinelli.
Thank you. Thank you for coming in. The University of New Hampshire owns a very large amount of land in the town of Durham.
Yes.
Would you feel the same about them? They own not only the land on the campus, but they own so much of the land surrounding it that we can't expand our commercial activities. Would you consider them to also be suffering from the same malaise as the federal government in this instance? And should they also have to be held to the state be held to the same standard?
One, those lands are already in the hands of the University of New Hampshire. I mean, that was a grant done by the state, and actually I think Dartmouth preceded the existence of the state, so, because that was originally an Indian college.
It's in Durham.
Oh, in Durham. I thought you said Dartmouth, I'm sorry. I think it creates an institutional problem for the state, for the town of Durham, but it's already water under the bridge. We're talking about what happened. We don't make retrospective law. We can't undo what has been done. I would certainly question whether we, the state, should sanction further acquisitions of land in the city of Durham, because it will make Durham less capable of supporting itself. I certainly don't think we should support Durham. I mean, financially, you know what I mean. I don't think that's a burden to the state.
Okay. I see no more questions. Thank you very much, Representative. Robert Gaida.
Thank you, Mr. Chairman, members of the committee. For the record, my name is Robert Gaida. I reside in the town of Warren, New Hampshire. I had the privilege of serving 6 years in this body some time ago, and it's a pleasure to be back. I'm here testifying on behalf and in favor of the bill from the Senate only if amended. The amendment is critical because we don't want to foreclose on the federal government's ability to acquire certain properties if they meet the stipulations in RSA 121. The bill unintentionally, inadvertently, was worded in such a way that it foreclosed by adding properties from the National Forest into that 2% limit. We need to fix that, and that amendment does that. And that amendment, by the way, was worked out with direct communications with DRED. We went to visit them, they said this is what needs to get fixed. And it's an absolutely valid point. So the amendment, yes, and the bill as amended, yes. And here's why. The town of Warren is within the confines of the presidential proclamation of 1929 that established the White Mountain National Forest. Our town today is 62% owned by the White Mountain National Forest, the land mass of our town. For that, we get $24,000 a year in payment in lieu of taxes. It does nothing to help the town. We're facing another potential acquisition by the National Forest, which would take 550 more of the best acres in our community and take them out of the tax base and out of public use, basically. So there is a reality. 19 towns within the boundaries of the White Mountain National Proclamation 1929 have gone out of existence. These were towns that had small stores, loggers, mills, small schools. 19 communities have gone away. The law of unintended consequences. Warren's tax base, we are struggling. I'm the town moderator, I'm on the school board. We also work very hard to keep our taxes down, but as you continue to take tax-providing properties away, put them into the realm of PILT, payment in lieu of taxes, which is very, very minimal, you hurt the town's ability to survive. 19 towns are proof of that. There's no prohibition in this bill as amended for the properties that Mr. Simpkins spoke to from DRED, Forests and Lands. What this does is it gives a voice. If we don't pass this bill, then any town affected by the White Mountain National Forest has no voice in the taking of that land. Every other city and town in the state is allowed to have hearings. But those towns in that proclamation boundary aren't even allowed public hearings. It may happen, it may not, but it is a matter of due process that those towns and communities are denied, according to law, the very same rights that other towns have to speak to whether or not this is a good thing for our community. I think that due process issue is compelling. The ability of a town to have a voice in persons donating or selling property to the federal government is extremely important. There's no one in this room that is a stronger advocate for private property rights than myself. But that said, as Representative Itch indicated, our Constitution says you give up certain things. And if what you're doing to your community is causing harm to everyone else in that community, whether it be robbing a store, burning down a building, or giving your property over, you are harming the ability of the taxpayers to sustain that community. And that is the origin, that is the reason that this bill was put forward, was to give a voice to towns that don't have one, to establish rational limits, and to keep the federal government's acquisitions to a manageable level. We would love to see DRED take over all these properties, because DRED does a magnificent job of what they have and for our state and our people and our resources. That said, I'll answer any questions. Again, I testify in support of the bill and the amendment.
Thank you, Mr. Kyle. Representative Francis.
Thank you, Mr. Chair. Thank you for taking my question. I'm going back to your comment about 19 towns that have gone out of existence. Is there a true cause and effect relationship here between federal government? I mean, the federal government taking land Or is there a dynamic that's going on with just population change in that area? People moving out, people dying, you see what I'm...
I see where you're going, and I will tell you that it's an empirical statement. It's not based upon statistical facts. But I don't find any other part of the state where 19 towns have gone out of existence after a singular event by presidential proclamation declaring these lands belonging to the federal government. So, it's not statistical, but it certainly is empirical. These towns went away, and they're all within the confines of the national forest. Whether that's because of restrictions put on logging or environmental, things, is possible. I cannot certainly say that.
Follow-up question, please?
Follow-up.
So would you agree with me that there might be a multidimensional effect going on here? That it might not be strictly one-to-one national forest versus...
Certainly, I'm sure there are other factors,
Yeah.
but the fact remains 19 towns have gone away, and they're all within the boundaries. So there's something going on there.
I see that, yeah, thank you.
Representative Watson?
Thank you for taking the question. Would you agree that there's also a benefit to the towns within the boundaries from the fact that they are within the boundaries, that tourists are coming in, that people are buying things in the store that are beyond the hill? So that
No, I
yes,
would disagree with that.
You don't agree with
And I'll
that?
tell you why. Look at Loon Mountain, within the boundaries. It's not the national forest. It's Loon Mountain as a commercial enterprise that develops that tourism. There's very little in the way of tourism that goes specifically to the national forest to walk through the woods, relative to what Loon brings in, Clark's train bears, and those types of establishments that are private commercial establishments. They draw the bulk, by far, of the tourism industry into the White Mountain region.
As was suggested earlier, I think this is multidimensional and you're being a little narrow in crediting
Excuse
it
me.
all in one.
Not your turn to testify.
Thanks.
Representative Spang, then Representative Mays.
Okay, thank you. We wanted to conserve our land. It's a very significant piece of land. It's got a Wildcat River going through it. It's part of 2,500 acres of prime wildlife habitat. We had several different avenues for doing that. We could have gotten an easement through the
Do we
town.
have a question?
I'm getting there, I'm getting there. Could have gone to the town, could have gone to the Nature Conservancy, could have gone to the town to give them our easement. We could have gone to the Nature Conservancy. We could have gone to Fish and Game. We chose to go to the Federal Wetland Reserve Program because they were also going to help us manage our land. Is there any difference to the town of Durham, whether we give that easement to them or TNC or whatever, than if we are giving that easement to the federal government? And if there is no difference, then why are we targeting the federal government specifically and not all these other organizations? Or we could have just put a deed restriction on it without an easement to anybody else.
It's an excellent question, and I'm not familiar with the town of Durham, but speaking to the concepts, there is a very large difference between ceding land or conservation easements to a federal government that does not live in our state, that has no interest in the welfare of the individuals and the communities of our state. They have their own agenda, whatever that may be, constructive or otherwise. When you cede it to a local community or an NGO that's local, has a local representation, or to the state, you have a voice, you have the ability to directly influence, without an act of Congress, what's going on with the management of those properties and with their disposition if that ever takes place. So I think there is a significant difference.
Follow-up?
Follow-up.
Thank you. The only, would you consider that to hold true, given that the conservation easement itself that we agreed to has the stipulations on how the land may be managed? And it's virtually the same, no matter which of those 3 or 4 organizations we had gone through. They can't influence how we manage our land. outside the realm of what we have in writing, and the easement is virtually the same with those 4 different options that we have.
Then your statement answers itself, your question answers itself. The fact still remains, we're looking at going forward. The federal government is, and agencies within the government are on an aggressive course to take significant pieces of property in New Hampshire and significant tracts of land, far beyond the 2%. This is why our legislature back in 1935 put this law into effect, because they could see a situation where a majority eventually of the land of the state of New Hampshire is controlled by the federal government, regardless of the agency. And so, as a society, we come together for the benefit of people, and when you start restricting the uses of land from what people would need to sustain themselves, whether it be farming and agriculture, or timber harvest, or whatever it might be, you then begin to harm, for the long term, the ability of that state, that community, that county, whatever the division may be, okay, to sustain itself. And that's the underlying thrust behind the 2% limit, as well as the 5% cumulative limit valuation-wise for the town.
Representative Mays and Representative Wright.
Thank you, Mr. Chairman. Thank you, sir, for taking the question. During your testimony, you spoke about an additional piece of land in Warren that is going to be taken. My question is that a private entity selling to the United States government?
It is a private individual donating to the White Mountain National Forest, which parenthetically is having problems because the terms under which this fellow wants to donate it don't meet the terms under which a national forest must operate the lands that it holds. So there's a problem there. But again, 550 more acres, we have no problem with that going to DRED. We don't want the federal government owning it. There are certain, we can talk to DRED. 2 of us went and sat with Mr. Simpkins in his office for an hour and a half, and we resolved any concerns that he had with respect to the inadvertent problem created by the Senate bill. We can do that here. I can't go to Washington. And I can go to a federal office and I might get heard and it might someday wind up in some hearing. The point is the control that's local, that's locally based, and local even to Concord, in New York State is a much better way to do things.
Follow-up, please.
Follow-up.
So the bottom line is if this individual can't come to agreement with the federal government, that land is not going to be taken by the federal government. He's not going to sell it. He's going to find some other place to donate it.
In this instance, that would be true.
Which
But I
would
can tell you
have,
that
which ultimately have the same effect. The land would still be out of your tax base.
Maybe.
It may, you're right, I apologize. It may leave your tax base. So I have a hard time understanding the difficulty of a private individual making a decision based on their individual family needs when the state prides itself on their ability to make their own decisions like that, whether they sell it to A, B, C, or D.
If I may,
They
Mr.
donate
Chairman.
it. But again, I use that term donate, sell interchangeably because it's going to be taken out of something and given something else.
If I may.
Mr. Geiger, yes.
Thank you, sir. I would counter that with the thought that every planning and zoning board in every town in the state truncates the property rights of individuals who own and pay for and pay taxes on their private property. What things you can build and can't, what sizes you must have. So those restrictions exist to minute detail in local communities. So again, to state that, to state your case, I think is seeing one very small aspect where we already truncate people's property rights in considerable ways.
Representative Wright.
Thank you, Mr. Chairman. Thank you for coming here today to speak to us.
Yes, sir.
I know you're not the federal government, but you seem to have had some experience with this. When the federal government comes in and takes a piece of property like that, or buys a piece of property, are they buying the fee of the property, or are they buying the conservation easement?
I can speak to my experience in the town of Warren. They buy the property. They just buy the property. Back in the in early 2000s, when I was a selectman and chairman of the board, they were doing what they call rationalizing their boundary, and they were killing us. They were taking property and buying it. The owner's happy to sell because the federal government has unlimited pockets. And so it was harming the town directly. Our tax base kept getting chopped, and pieces and piece after piece after piece got bought. And we wrote a letter, and to their credit, they acknowledged, yeah, we understand now that that's a problem, so we will cease, and they did. problem still remains that towns in the White Mountain National Forest boundary, proclamation boundary, do not have the right under current law to even hold a hearing. And that needs to be remedied.
Anybody else for Mr. Guida? Seeing none, thank you for your testimony.
Thank you, members of the committee, Mr. Chairman.
Thank you. We're running way over, we still have 3 speakers left at least. If there's anybody else who wishes to speak, would you fill out a pink card and pass it up now? Ann Cartwright. And I don't think we can give you the full 10 minutes you asked for, so please, as brief as possible.
Thank you, Mr. Chairman. I'm Ann Cartwright. I was a rep for a couple of years. My husband and I own a tree farm in Alstead, New Hampshire. We are in the proposed expansion of the Silvio Conte Wildlife Refuge. I would like to speak to the original bill and the amendment in a couple of ways. First of all, I'd like to say that the RSA 121, which has been in the book since 1935, is good, but it is limited as far as it needs more clarification. I think the original bill from the Senate, although it's good in some ways, does have some problems, and I do support the amendment that has been proposed concerning taking out the White Mountain National Forest acreage from the 2% within the boundaries of the White Mountain, the original 1929 boundaries of the White Mountain National Forest, which is the bulk of the White Mountain National Forest. There is a much smaller amount of land outside of the 1929 proclamation boundaries. Now, the thing that I think is very important, if you could hold it up, is to show visually how much acreage the Silvio, I'll start with the Silvio Conte. The Silvio Conte Wildlife Refuge, how much acreage is the federal government considering over time? They expect this to take 50 or more years to acquire, going from the Canadian border to the ocean. Now, if you just take the New Hampshire portion of that, which is the Connecticut River going up there, the right side of it, that includes over 1.9 million acres of land. And then, so you've got the Silvio Conte, that is a huge section of New Hampshire, and in fact, blocks, therefore, the state's ownership and care of the Connecticut River. Now, up in the right-hand corner, Joe, if you could show them where that is. The right-hand corner that's left, right there, that is already being acquired by the U.S. Fish and Wildlife Service under the Umbagog National Wildlife Refuge. Now, below that is the White Mountain National Forest that is already owned by the federal government. Now, something happened since I was here even the last time. In January, the U.S. Fish and Wildlife Service announced that a new wildlife refuge called the Great Thicket. Now that is from the coast of New Hampshire across the state to the, well, it goes down before, we're not sure exactly. Their map is not the best, and I have copies of that if whoever has, hand them out. Great Thicket, those. It's not as detailed a map. That is the U.S. Fish and Wildlife map of the Silvio Conte. So the Great Thicket includes that part, southern part of New Hampshire, all of Massachusetts, Connecticut, most of it, a little section it doesn't, all of Rhode Island, the Cape, the islands, into New York to the Hudson.
Can you get back to talking about the bill, please?
I'm not trying to show the extent
I
of New
understand what
Hampshire.
you're trying to do, I'm trying to get you back to the bill.
Okay, the extent of New Hampshire. Therefore, if we do not have this limit, the only remaining portion of, as it's planned now, is a very small portion in the center, lower center right of New Hampshire that is not, that the U.S. Fish and Wildlife Service is not at the present time looking to acquire. So, there are 93 towns in the Connecticut River watershed, and it goes way inland, you know, into the state. I also would like bring up one thing. The federal government, in other cases of the Patu fire out in North Dakota, they lit a prairie fire to burn some land in the national park, or whatever it was, I can't remember the name of it, in South Dakota. On a day when it was windy, during drought conditions. The ranchers who live and have thousands of acres in the area and have their cattle and hay requested they not do a prescribed burn, that it wasn't safe. They ignored them and they did that prescribed burn and burnt, instead of the 130 acres they proposed, they burnt approximately 14,000 acres. 11,000 of the acreage of these ranchers, whose whole supply of hay and grassland was therefore burned off during that fire. Now, originally, U.S. Fish and Wildlife Service, who was the one who did this, said that they would make restitution to the ranchers. However, the Department of Agriculture is the head of the U.S. Fish and Wildlife Service, and that happened in 2013, and they have now stated that they will not pay any restitution to the ranchers. Now, if that were a private individual who owned that and did a prescribed burn, there would have been consequences and there would have been restitution. The federal government has to this day given no restitution. They do not seem to have a way for us to hold them accountable for their actions. Another example would be the Animas River in Colorado.
Excuse me, we're getting way off.
I'm just
I understand what you're doing. Would you please bring it back to the bill?
Okay, so therefore, I would request that you pass the bill with the new amendment in order to protect the property owners and the towns and the state and their economic and viability within the state of New Hampshire. Thank you.
Thank you. Any questions, Mrs. Cartwright? Representative Spang.
That's okay.
Okay, thank you. Thank you for your testimony.
Mr. Chairman, I did have a question.
I'm sorry.
No problem. I'm curious about this map.
That's from the Great Thicket.
Right, but why is it goes up and then it comes down to eliminate most of southern Vermont, southern New Hampshire, but goes over to Merrimack Valley and up north? Why is that line down and then up? Why isn't it right straight across?
I think it's because the Silvio Conte already exists. I cannot speak for sure because it is not a detailed map, but that would be my guess.
Well, being our area, I find it very divisive to, not from you, but whoever did this, to just say, oh, we don't need anything to do with southern New Hampshire, southern Vermont, we'll just go down and go back up to make sure we protect Merrimack Valley. Thank you for listening to me.
Thank you. Thank you for your testimony.
Thank you, Mr. Chairman.
Taylor?
Thank you, Mr. Chairman. Yes, that's correct. Good afternoon, ladies and gentlemen. My name is Julia Taylor. I have the honor of serving as the Executive Director of the AMENDED.
Can we have attention to Ms. Taylor, please? Thank you.
Thank you.
Proceed.
I have the honor of serving as the Executive Director of the Land and Community Heritage Investment Program, LCHIP, the program whereby the state assists with conservation of land and preservation of historic buildings. The program has been in place since 2000 when the legislature created it. Some of you may have had a chance to participate in that creation. You did a wonderful job. The program is highly successful, well beloved in communities, and I'm here to raise a concern that this bill may prevent the opportunity for landowners who wish to take advantage of federal funding. This may eliminate much of the funding that is used to match LCHIP grants. Our grants are matching grants. They require a 50-50 match, 1-to-1 match, but on average, at this point, we have brought in, the LCHIP grants have brought in more than $7 for each dollar of state money, so it's a remarkably good use of state money. I fear that this bill, if passed, would prevent the use of the Forest Legacy Program, which brings money for conserving forests that can then still be used for timber harvest, and the Agricultural Land Protection Program, which brings in money to help with protecting agricultural land and allows that land to continue to be used for agriculture, for growing local food for local people.
Any questions from Mrs. Taylor? Representative Rice, Representative Oxnam.
Thank you, Mr. Chairman. Thank you for your testimony. Trying to boil this down into simple terms, are you saying that you would rather see people be able to sell their lands to the federal government so that you could continue with your funding of through your program as opposed to helping to ensure the economic viability of a town? Is that what you're saying?
I am not saying that at all, sir.
Then can you interpret?
Yes. Our grants are selected through a very careful process, and they have local support, or we don't provide money. And we have some good numbers that show that our protected land has a very important economic value to the communities that they're in as well. I mean, you have the choice to balance various ways. Any community has a chance to balance various kinds of economic development, and our grants lead to certain kinds of economic development. Leaving land in private ownership for other sorts of development has another kind of economic benefit. So there are balances that are struck in communities and by landowners at all times.
Follow-up?
Is the land that the federal government has its eye on, for lack of a better term, is that likely to be the same land that would be considered by a town or by some entity for economic development within that town?
I'm concerned about the unintended side effect of this bill preventing use of federal money for desired land conservation in communities.
Representative Oxnam.
Thank you very much for your testimony. I'd just like you to double check some numbers for me if you're able to. Is it actually the fact that the National Park Service has provided over $20 million in historic preservation grants to New Hampshire since 1969, that they have stimulated over $100 million in historic preservation rehabilitation projects in New Hampshire through historic preservation tax credits, over $37 million in land and water conservation funds through state assistance grants, and that $2 million directly into the New Hampshire economy through the national park system, of which we have 3.
I'm sorry, I have no national park numbers, sorry.
You did speak about the LCHIP funds.
Yes.
And would the Land and Water Conservation Fund, state assistance be part of the LCHIP, or is that in addition?
That's additional money.
That's in addition. Thank you very much.
Representative Gould.
So the main thing is that I gather from you is that, will this affect the matching funding that comes from the federal government?
That is my concern with this legislation.
I want to just clarify, that's your concern that we don't know for sure in either direction, is that correct?
As the legislation is written, it appears to impact the ability of the federal government to participate in conservation easements, and that's where my concern lies.
And you believe that's the case also with the amendment?
I have not seen the amendment, I can't speak to it.
Thank you. Representative Spence.
Thank you. You do a wonderful job.
in the process of selecting projects that are going to be funded by LCHIP, are there projects that are brought forward by the federal government for consideration for approval?
No, the federal government has never applied for an LCHIP grant in their own right that I'm aware of. It is usually federal money that is sought or has been secured by another eligible applicant, like a land trust or a community.
When a project, all of the projects that are applying for funds are being evaluated, is one of the factors that is being weighed whether or not the federal government is providing funds? Or is it just, here's the project, what are the merits of the project, and
The source of the match money, as long as it appears to be probable for the grant, is not of a major concern to the selection process.
Further questions? Mr. Representative Wright.
Thank you, Mr. Chairman, and thank you for coming today. You talked about conservation easements, and that's your biggest concern. But what I read from this is this is about acquisition of land, not conservation easements.
Because the text that I see of the legislation from the state's website includes mention of conservation easements, my concern is that the prohibition can be broadly applied to include conservation easements as well.
I see no other questions for Ms. Taylor. Thank you for your testimony. Joseph.
Thank you, Mr. Chairman. My name is Joe Cartwright from the town of Alstead. Our selectman is not here today, so I brought a letter along that they had sent to the Department of Revenue and Economic Development. I passed it along earlier. Our town is in the focus area of the Sylvia County. We're 6 miles away as the crow flies from the Connecticut River, and we're in their focus area, the Schuylkill River watershed. Our town's going to be over 30% in the acquisition sites of the federal government. So in February, we had a warrant article put on the ballot, and the townspeople had a chance to vote on that in March. And the results were 264 against the acquisition to 191 for. And the selectmen sent the letter that I passed around to the Department of Revenue and Economic Development, asking them to notify the U.S. Fish and Wildlife Service that our town was opposed to any acquisitions. And so I just want to make sure that the committee was aware that the process does work, and we're hoping that the U.S. Fish and Wildlife will abide by our wishes and follow RSA 121. Thank you.
Thank you. Questions for Mr. Cartwright? Representative?
Just a question from the, did you have a letter, sir?
Yeah, I passed along here somewhere, so it's passed along.
Was that, all right, I think the confusion then might be, may I? I think a packet came by, but it wasn't, I mean, part of these, you had a number of things in that, and it.
Yeah, it got stuck in there. I think that's what happened to it.
Single copy or multiple
That's
copies?
it.
You pass it right on down to that man down there.
Thank you, sir.
Copy of the bills, there's other things in that packet too, did you want?
I think all these maps were attachments to this
Just
packet.
pass down the letter for the clerk.
We're not guilty of anything.
There were some other maps that
Okay. Okay. Further questions for Mr. Cartwright?
Mr. Cartwright, is it?
John, is that the whole packet right there? I'm sorry. I'm
No,
just trying to
this
figure
is mine. There was pieces that, there was a couple of maps.
Because that dark map at the back of yours,
Yeah,
we never got those up here, so is that part of the packet?
that was, yeah, so we got a couple of them.
See, those stop there, so we have no idea what the original packet looked like.
Okay. Representative Spang, you had a question? Keep yours.
Mr. Cartwright, was the town of Alstead
Alstead.
left with an impression being included in the Silvio County geographical area meant that the feds were indeed going to move in and take their lands by hook or by crook?
No, we all knew that it was a willing seller. The focus area on the Hoell River watershed includes Alstead, Surrey, Gilson, and Marlow. And Alstead is what they're looking to acquire, hope to acquire up to 35% of our town. And the people knew it was a willing seller. It wasn't eminent domain or anything like that. But we were against the idea because it was said earlier, the loss of tax base and the loss of the use of the land, because a wildlife refuge is totally different than a forest. Restrictions on refuge land is very, very more. Hunting is much more restricted than state law. Fishing is more restricted than state law. There's a wildlife refuge in Peterborough that you cannot run on. All those kinds of restrictions, that's what we were against.
Oh,
Is Alstead aware that the Silvio Conti is appropriated probably around $1 million in a good year to acquire land throughout their entire area from Canada to Long Island Sound? And the likelihood of their getting any large amount of land from any one town is extremely high.
Yes, but they designated focus areas. Sprague Brook, Richmond, New Hampshire, the Hoell River watershed, and the Muskoma watershed are the focus areas this time around. And they're going to focus the next 10-year plan on those areas. They're going to try to acquire land in that focus area. That's their goal this time. The last time it was up in Umakah.
Thank you.
thank you. Any Representative Oxnard?
Thank you. Yes. As a follow-up to the question about what it means to be within these borders. This is an attempt to have flood protection measures and watershed protection measures, that land can be acquired. It's not, you know, the maps make it look like the federal government is going to come in and take 1/3 of the geographic area of New Hampshire. But I think there's a fundamental misunderstanding of the attempt to safeguard the water resources, clean water of the Connecticut River, and areas like Muskoma, which is like my area, are to be protected by that. So do you see this disconnect in the comprehension of
No, I
what's
do not,
intended
because
here?
the state of New Hampshire already has water protection. The Hoell River is already a designated protected river. The Sugar River is already a designated protected river. All these rivers are already protected by New Hampshire state law. So the clean water is already under state law. And the lands in our area are not flood control. There's pastures, there's farmland, there's wooded land, it's all type of topography.
Thank you.
The watershed.
Any additional questions? Seeing none, thank you for your testimony. Is there, I have no more pink cards.
Thank you for coming out.
So, yes, there's nobody else who wishes to. Is there anybody that wants to speak a second time to clarify earlier remarks? Seeing none. Gentleman McConnell, will you do the honors with the blue card?
Okay. All right, we've got 3 people signed in against. Larry Sunderland from the New Hampshire Audubon Society, Jason Stock from the New Hampshire Timberland Owners, and Jim O'Brien from the Nature Conservancy. In favor, we have Senator Kevin Abard, Ann Cartwright, Joe Cartwright, Art Bingham, Senator Abard's Senate District 12. The Cartwrights are from Alstead, excuse me. Art Bingham from Keene is in favor. Bob Guida from Warren. Representative Dan Itzy from Rockingham 10. Representative Eric Eastman from Hillsborough District 28. And Representative Kathleen Souza from Hillsborough 43.
Okay, thank you very much. Pass that down. That concludes the hearing. And I guess the rule of thumb is if there's one L, it's Al. If there's 2 L's, it's all. Always.
Pleasure.